Okay, good afternoon.
Good afternoon.
Okay, do want to remind you that this oral argument is being live streamed on YouTube so that the public can observe it. Each side will have 20 minutes for their oral argument. Appellant's entitled to divide that time between opening argument and rebuttal argument. There is a clock on the screen, but if you want to let me know how much time you wish to reserve for rebuttal, I'll try to help in that regard. The other members of the panel, of course, Judge Lambert and Judge Traver, I don't know where they are on the screen, on your screen, but we'll go ahead and proceed.
Judge Traver unmuted?
I am now, sir.
There he is. We can hear him now. I'm sure that's a good thing, but I think it's probably appropriate.
I tend to mute it until I don't have to.
Oh,
All right, Mr. Lyon, you may proceed.
This is actually Ron Hertel. I'm a partner at the same firm as Mr. Lyon. I've sent in a designation that I would be arguing today.
Okay.
I'd like to, may it please the court, I'd like to reserve 4 minutes for rebuttal.
Okay.
And I can go ahead and do the math, I guess, off of my clock in the corner there. Judge, this case is about whether a lost or destroyed will be admitted to probate, and the presumptions that arise when a will is lost or destroyed. It also deals with dependent relative revocation. So some quick background. The decedent was a divorced father of 3. After he divorced his wife, there was a split in the family where one son kept in contact with dad and the other 2 did not, and so there was a falling out with 2 of the sons. What we have on the record as evidence are 2 of the decedent's wills, one being an earlier 2015 will that shows that his estate plan was to leave his corpus to a number of grandchildren, 1 son being my client, John Bacino, and a few charities. He specifically excluded the other 2 sons. He then amended that will in 2017. That will also disinherited the 2 sons that are represented by Mr. Bear. However, about 6 days prior to his death, he sent an email to one of Mr. Bear's clients, his son Mark, basically stating that per conversations with his priest, he feels the need to forgive his sons for his perceived disrespect, and that he wanted his sons to all share in his estate. That email was put forward by Mr. Bear's client in response to a petition to probate lost or destroyed will filed by my firm. That petition was accompanied by an affidavit signed by Jill Colato, who was a disinterested witness to the signing of the will. She actually was one of the attesting signing witnesses to the lost will, but she put her affidavit on top of a photographic copy of the purported lost or destroyed will. The dispute arises in that Mr. Bear's client, Mark Bacino, feels that the email that he received from his father stated an intent that he wanted to destroy his will and thereby revoke any estate plan, and instead to move forward on intestacy. We believe that the lower court in its order, well, let me take you one further. There was an evidentiary hearing held concerning what evidence there was that this will was destroyed on purpose, or whether it was merely lost or destroyed by accident. The result of that was an order, which is on page 80 of the record, signed by Judge Patty Christensen, basically finding that the presumption that the will being lost, that the presumption is that the decedent destroyed the will with the intention of revoking a testate estate plan.
That is the presumption, right?
That is the legal presumption whenever you have a lost or destroyed will.
And you have to overcome that presumption, right, as the petitioning party to admit the lost will or destroyed will.
All correct.
Okay.
So
that would be presented through evidence at the hearing of which we have no transcript.
that is correct.
Okay.
However, we believe that the court had misinterpreted the burden in that the ruling, the judge's order states that the court finds the evidence insufficient to overcome the presumption that decedent destroyed his last will and testament dated November 21st, 2017, and therefore died intestate. All that is required to be shown, however, is competent substantial evidence, of which, even though we don't have the transcript from the hearing, we do have the exhibits from the hearing that were admitted into evidence. Those are part of the record. And even without the transcript, if we review what was admitted into evidence, that is and amounts to competent substantial evidence, even without.
Let me ask you about that. Let's assume we had a transcript, and let's assume there was a lot of conflicting testimony, such that there was competent substantial evidence to support the idea that the decedent intentionally revoked the will, but there's also competent substantial evidence to support the idea that it was not, the opposite result. In that scenario, and the trier of fact then makes credibility determinations and finds that one side's evidence is stronger than the other. So does the mere fact that one side, this is theoretical because we're limited with lack of transcript, the fact that each side may have competent substantial evidence, are you arguing that if the proponent of the destroyed will wins automatically as long as they have something? Or
No, I'm sorry, I didn't mean to cut you off.
no, go ahead.
I think that's where the reason that's a good question is that's where I find the error in the judge's ruling. In even without having the transcript, we're no longer running under the presumption. Once the substantial competent evidence is in the record, which we do have, even though we don't have the transcript, that presumption then goes away by operation of law. And so this court, on a de novo ruling with the evidence presented before it, could find that the email, which is also in the record, that basically started this inquiry, whether that email itself constitutes competent substantial evidence such that the presumption has been rebutted. So what the lower court should have found, if it was going to get into that inquiry, is that the presumption was set aside, and now, based on the evidence as adduced at the hearing, that it either is revoked or is not revoked by basis of the presumption. So basically,
Are you saying
whether or not it's been,
order? Are you saying at the judge's order it said that your client's evidence was insufficient to show that the will was accidentally destroyed? That would have been okay.
if the judge had said the evidence shows that the will had been destroyed, that would be okay, correct. But what it says is that the presumption was never even disturbed in the first place. And to me, that's the error. That is error on the part of the court, because even just a cursory review of the email that we're talking about, it specifically states, I plan to create a new will. Those were the words of the testator himself 6 days before he died. And so the fact that he said that is that competent substantial evidence of a different intention.
If you wanted to achieve the intent of having all three sons share in the estate, and you have this will that does otherwise, and you call up to make an appointment with your lawyer to draft a new will, what is the only way in the interim that you can achieve that intent?
To destroy a will or to revoke? Is that your question? There's a number of ways, if that's the question.
Well, I'm saying you've done this letter saying, I want to share. Now the person wants to do a new will, but they know logistically, it's going to take a few days.
Sure.
What's the easiest way to achieve that goal before making the new will?
Sure. Any sign of an intention of revocation. We are talking about an attorney. He was an attorney, at least in Connecticut. I don't believe he practiced for decades at this point, but all of the evidence points to him drafting his own wills. So he wouldn't have had to go to another attorney. But if presuming that he understands how revocation can work, he could have just marked line through the page and just said, this will doesn't count. Anything to that. But all that we know is that we can't find his will.
Well, I mean, because his email certainly suggested that he thought that his time remaining on Earth was coming to an end, which he was apparently, bad or good, he was right. 6 days later, he passed. So, following up with Chief Judge Evander saying is, this fellow's an attorney. He just says, well, okay, I can't get to see my attorney yet. I'm 86, so maybe I shouldn't be drafting my own wills. I've made it clear what I want to have done. I'm just going to rip up my 2017 will. I, as an attorney, know it would go by intestate. And, if he wanted to refine that by seeing an attorney to draft it something a little bit differently, but he ran out of time. So sounds like, where we are is sort of where he was going, right?
If we take all that to be the truth, then yes, then that would have been clearly his intention. But what I think,
but you want us to, I mean, we're talking about, we don't have a transcript, so we don't know what people talked about.
right?
But like we have evidence, including an email, and that email is pretty damning to your side, I would think.
Except for the intention to create a new will that he clearly says, I plan on creating a new will, and he even asks his son to tell me what specific pieces of property would you like to have, and presumably he would put those personal property dispositions in his new will, but that never happened.
Let me ask you this.
Yes.
What evidence is in the record, and not just that there's an attachment somewhere, what evidence is in the record that supports your contention that he accidentally revoked the will? Is there anything, or could we only get there with a transcript?
I don't believe there's any evidence that he intended to revoke the will ever. That goes to our second argument, which is the issue of dependent relative revocation.
Now, my question was, what evidence is in the record that he accidentally destroyed the will?
Just the fact that no one found it. I guess that's it.
Well, if that's the case, then doesn't the presumption govern?
Well, that's the thing, is the presumption goes away once there is the competent substantial evidence on the record, which we know just means basically a scintilla of admissible evidence that says otherwise. And
Yeah,
so,
but normally those cases where they find evidence is someone who had a motive, if you would, to have the will destroyed and had access to the place where the will was located. I mean, here, particularly without a transcript, we have no evidence of that, right?
that's right.
So do we have any evidence that supports the petition that in essence he accidentally destroyed the will?
Accidentally, I don't believe there's any evidence that he accidentally destroyed the will.
Or I should say not intentionally.
Yeah, if he did destroy the will, and that again, this goes to the second point, he would have done so with the intent to create a new will, and that is what is dependent relative revocation, that I'm revoking this will.
I think your argument in the briefs, and correct me if I'm wrong, was that this guy was a lawyer who changed his will often, and whenever he wanted to change the will, he would instruct that the last one be destroyed. So I think your argument is arguably speculative, that because there was an old will that was there and he'd said he'd previously destroyed it, that he must have made an accident. But that's nothing more than speculation, correct?
Yes, but I was trying not to make any reference to items that would have been in the transcript that we don't have. I didn't want to argue that to the court today without the transcript, but yes, that is contained within the brief. Yes. So,
I mean, even if we give you that benefit of the doubt, isn't that still speculative?
well, I mean, if the court was going to accept that, then we would ask that it also accept the fact that what was found was the 2015 original will, which presumably would have been destroyed when the 2017 will was signed. And, you know, so it didn't actually follow the pattern that he's talking about, that was described in the letters in the record and what's described in the brief, which is his pattern of keeping photocopies of his prior wills and keeping the original of the good will. So the fact that we have a photocopy of what we would call the good will and the original of one of the what we call a revoked will, to us, that leads to the conclusion that he accidentally destroyed the wrong will. We would have found the original of the 2017 will. But again, I was trying not to argue that because that's not on the, because we don't have the transcript, unfortunately. But
Yeah, but you argued it in the briefs.
I do. Yes, my Mr. Lyon argued that in the briefs.
Fair enough.
But with the dependent relative revocation, what I wanted to say before I run out of time is that says that when a party does go ahead and destroy a will with the intention to create a new one, and then there's a presumption that when he expresses the intention of creating the new will, that it's presumed that he wanted to die testate, not intestate, and that he would not have revoked the prior will, but for the belief that he would have had time to execute the subsequent will. So,
but that's a rebuttable presumption against intestacy, and again, without the transcript, we don't know that the rebuttal, taking your argument, that we don't know that the rebuttable presumption was not met or overcome by the evidence presented at the hearing before the trial judge.
we believe it should have been, just by yeah. Well,
I mean, you should have. I mean, you know,
it was just clearly
say that without a transcript.
I understand. It was just, to us, it was clearly stated in his email, I plan to create a new will. And I believe I'm out of time.
Okay, thank you.
Good afternoon, Your Honors. Dennis Thayer on behalf of the appellee in this case. Just real briefly on the statute of fact, the statement of facts. If you look at the email that was prepared by the decedent, he had a falling out. I think the words were he was equally disappointed with all three sons, including the appellant in this case, as he failed to move Florida to take care of him in his later years. And what I think is also crucial as to the issue of the lack of transcript is that there was the testimony of three people at the hearing. We had the two parties, the two brothers, my client, Mark Pacino, as well as his brother, John Pacino, as well as the curator, Mr. Gepner. So I think it's critical that there's no record. And I think that the case that we cited of Snowden versus Wells Fargo Bank, where you have a de novo standard of review on appeal, is that there's still that presumption of correctness with the findings of the trial court, that without a transcript, there's no way for the appellate court to reweigh the evidence and reconsider what the trial court's decision was based upon. And I think that the order that the court, that Judge Christensen entered, is factually explicit. She talks about what evidence she felt was credible, why she felt that here, where we did have a retired attorney that prepared his own wills, that clearly his intent was to go intestate so that his three sons would be treated equally. The one issue that I have, if you look at the presumption, is that this was not a case where there was no evidence at all to support our side, but we did have the email as well as the testimony, which we don't have a transcript of. And if you look at the Balboni decision, which was cited by the appellant, in that case, the court refused to probate a copy of a will, even where there was significant testimony about the opportunity of the one party to have destroyed the will. So it's not that there's just a scintilla of evidence. There's nothing that precludes the trial court from considering the competing evidence and determining whether or not the presumption has been overcome. So I think that the court's order is proper under the circumstances. She did consider the competing testimony, she considered the competing evidence and made the correct ruling that the matter should proceed intestate. And if we look at as to the second issue, as far as the intent to prepare the new will, the case that they cite in Ray Murphy talks about where the old will and the new will were substantially similar, that they would invoke the doctrine under those circumstances because of similarity between the wills. In our case, the email shows an express change in the testamentary intent where the decedent was not going to go back to the 2015 will. His intent was to come up with an entirely new testamentary scheme that would treat the three sons where they would share in the estate, which in other words adds the two sons that were not in either of the prior two wills to be beneficiaries of the estate. So our position is that the judge did rule correctly. We do not have the transcript. I think the other issue that comes up that has been raised is the issue of notice to the other beneficiaries. Our position, and I think if you look at what transcript we do have on the motion for rehearing, is that Mr. Hertel's co-counsel, Mr. Lyons, acknowledged that their initial service was not done in a manner that indicated that this was in fact going to be a contested probate matter. And they do have the burden, in our position, they had the burden of overcoming the presumption. The fact that there was not notice is something that they should have ensured happened before the hearing, where they had the burden of going forward and providing evidence, providing evidence to overcome the presumption that the will had in fact been revoked. That particularly they did receive notice, so I think the issues as to lack of notice cannot be properly raised by the appellant, that the other parties could possibly assert it at some later date. That's basically our position as to the issue of notice.
All right, thank you. Any rebuttal?
Sure, Judge. I think that I believe that the presumption that the will was revoked based on not finding it, and the fact that just a scintilla of admissible evidence showing an alternative argument will be sufficient to overcome the presumption. I think that the record, again, even without the transcript, the record that we have does show that scintilla of admitted evidence right there in the record. So with that, the court misapplying the presumption.
What is the scintilla of evidence that you're referring to?
The fact that the email that everyone's, that Mr. Baer's clients are also relying on, it plainly states, and I will read it, that portion for you.
Yeah, he says, I plan to prepare a new will and to name my CPA who lives here in Palm Coast as my executor.
That's right.
I think we're familiar with that.
And that he's asking if there are any personal property you would like me to put in there. I think that all points to the fact that Mr. Bacino intended to die testate, and that would disturb the presumption that he would have destroyed this will. There is no indication in here that he wanted to die without a will of any kind. Now, if we combine that with the presumption that arises under dependent relative revocation, that if he would have destroyed a will, if we're going to hold to the presumption that he destroyed this will, then I think the counter evidence or the evidence that works counter to Mr. Baer's position is that he clearly states, I intended to create a new will to carry out his estate plan. Just because he wants his other two sons to share in the estate, nowhere does he say, I want you to equally share in the estate, or that I want to disinherit my grandchildren that I specifically made provisions for in my prior wills, or that I want to disinherit the charitable organizations that I was going to give to. It's just everything points in the opposite direction, which is that he intended to die testate. And so the presumption that arises under dependent relative revocation, if we're going to take as true that he destroyed this will to revoke it, that he would have destroyed it and revoked it with the intention that the subsequent will would be what the court would probate. And we just don't have that here.
So if the judge had simply wrote, based on the evidence, I find that the decedent intended to die intestate, your case would be a lot worse today, I guess, in your mind, right?
That would be true, yes.
Okay.
Because that would be based on more than just a mere presumption. That would be based on the evidence presented. So
if she just worded it inartfully, you're saying we should have a do-over because the way it's worded?
I would say no, it would be a do-over because of a misapplication of the presumption. So for those reasons, we feel that that we should, the court should reverse and remand so we can go ahead and have that.
All right. Thank you both, and the court will be in recess.
Thank you.
Mhm.